In 1996, Bill Gates said, "Content is king." And boy, was he right. 3 decades later, it still occupies the throne. For lawyers, law firms, and companies serving the legal industry, content marketing and thought leadership marketing are a must if they want to build their books of business or increase their revenues. Hi, I'm Wayne Pollock. I'm a former AM Law 50 senior associate who discovered the world of content marketing and thought leadership marketing and hasn't looked back. In each episode of this podcast, I interview lawyers and legal industry in-house marketers who are doing big things with their content marketing and thought leadership marketing. This is Legally Contented. Welcome to episode number 19 of Legally Contented. I'm your host, Wayne Pollock. There are times in life when we come across things that are simple yet beautiful. And we come to understand that there's a lot going on behind the scenes to make that simplicity so beautiful. If you're a pizza lover like me, a great example of this is a margarita pizza. Margarita pizza has 4 or 5 ingredients. It's got dough, it's got fresh tomatoes, it's got olive oil, it's got mozzarella, it's got some basil, and maybe some sea salt and garlic sprinkled on top. Those are not many ingredients, yet they have to work hard and be of the best quality in order to come together and form this delicious pizza that might be the best pizza you've ever had. Simple can be beautiful, but it doesn't mean it's easy to pull off. Think about this theme as you listen to this episode, in which I interview 2 partners and co-leaders of Sidley Austin's eDiscovery and Data Analytics Group, Robert Keeling and Colleen Kenney. We talk about the practice's eDiscovery update. It's a monthly update that is basically a summary of relevant eDiscovery cases over the past month. And if you think that's kind of a strange conversation to have, well, I came across the eDiscovery update a little while back when I was doing some research for a client. I was impressed with how simple and beautiful this thought leadership marketing content was, yet I knew there had to be some serious work behind the scenes that made it come across so simply and so beautifully. Each update starts with an executive summary that includes a few sentences about each case that is going to be covered in the update, and then you could jump down and read more about a particular case that might be of interest to you and the takeaway from the decision. I reached out to Robert and Colleen, and I asked them if they'd join me on the podcast, and they so graciously accepted. During this episode, you're going to hear us talk about a number of things concerning the way the practice is run and the way the eDiscovery update is run. We talk about the first incarnation of the eDiscovery update and why the attorneys realized there was a bigger audience for it than they originally thought. What's kept the eDiscovery update going strong for almost 2 decades, the workflow behind each month's edition, including the division of labor between lawyers and how much time goes into each edition, what the feedback has been from clients and other readers, and how the group balances quality versus speed when writing each month's eDiscovery update. To me, this eDiscovery update is a great example, a quintessential example of a law firm using a classic express lane to become thought leaders on a topic. Drill down deep on a topic of relevance to your current and prospective clients and do it consistently. I thought these updates and the overall initiative are what a well-done big law thought leadership program looks like, and that's why I asked Colleen and Robert to join me. I hope you enjoy our conversation. Colleen Kenney, Robert Keeling, thank you so much for joining me today. Please introduce yourselves and tell us all how you came to be where you are today.
So I'm Colleen Kenney, and along with Robert, we are co-chairs of Sidley's eDiscovery and Analytics practice. I have been an attorney at Sidley, in fact, for 31 years now. I have not been doing eDiscovery for 31 years because I was there when we didn't have computers on our desks. We weren't worried about emails. We didn't even know what they were. I was also practicing when people had the don't ask for mine and I won't ask for yours philosophy. So people just pretty much ignored email. I think the reason I got into this particular practice at Sidley, and I'll keep it short to turn it over to Robert, was that in the early 2000s, I was working on some of the early cases that actually had eDiscovery and had a big eDiscovery dispute before a federal judge in the Northern District of Illinois, who's actually now on the Seventh Circuit. And In 2005, the firm was seeking to get what they called a task force together, a group of lawyers together to train people on the changes to the rules in 2005. And so I was asked to chair that. And then I'm going to turn it over to Robert because it has morphed from that, quote, task force to an entire practice that Robert and I are co-leaders of.
No, that's right. Thank you, Colleen, and thank you, Wayne. Robert Keeling, partner in the DC office of Sidley, and as Colleen said, we help chair Sidley's eDiscovery data analytics group. I was an associate at the time of Sidley forming that initial task force, and I got on in an associate role. And then later, when we made partner, helped work with Colleen to grow Sidley's practice into what it is today, which is kind of it sits as a central point within Sidley and serves as a resource to the firm, and then of course to all of our clients to help with complex eDiscovery issues, information governance issues, and really just modern litigation with modern discovery that we're all facing today.
It's funny, I can imagine people who went to law school in the late 90s or early 2000s said to themselves, I want to be an eDiscovery and data analytics attorney when I grow up. And yet here we are in 2022, and there are plenty of firms that have these practices. And I saw it as a junior associate back when I joined Decker in 2010. The amount of discovery that was coming through for some of these high profile litigations that we were working on, and how ill-equipped a junior associate would be to maneuver through the questions that popped up consistently in the course of what I would think would be a typical review. We're looking for responsiveness, we're looking for privilege, and just all of the issues that swirl around eDiscovery. It's fascinating to me that this practice has come up. It's not traditional substantive area of law like cannabis or gambling, where that's come to light more recently based on the legislative actions. This is part and parcel with litigation today and regulatory enforcement and other aspects of the law. So to me, it's fascinating that you all have risen to lead this practice that, 15 years ago, 20 years ago, was barely, a task force, let alone something that you could be a co-leader of. I want to give our listeners context here. The reason why we're chatting is because I came across your group's eDiscovery update. In the course of me doing some research for a client, I was looking for case law for courts that were approving the use of TAR, technology-assisted review, in discovery. And instead of going through Lexis or Westlaw, I decided to do what most people do. I Googled some keywords and came up with your beautifully done eDiscovery updates. And that's really the focus of the conversation, is to talk about the marketing and business development efforts that you all are putting in for the practice, really centered around your eDiscovery update. One thing I'm curious about before we move into the marketing and BD efforts that you are putting forth, in terms of your practice at Sidley, is it a practice that attracts clients as an entry point into the firm, or do you find yourselves tending to serve clients already using Sidley's services?
So that's a very interesting question. And I know Robert's going to agree with me. I'm going to take issue with one thing you said, Wayne. I think 15 years ago and maybe 10 years ago, the body of law of eDiscovery might not have been considered a substantive area of law. I think it is currently the most rapidly evolving substantive area of law that we're facing, including through rulemaking and case law. So I think that it has become a substantive area of law, and I think it is a fascinating, really changing everyday area of law, which and it leads me to my next point, which is Robert and I come at this with a slightly different focus. And before you think that it is Robert and the Robert and Colleen show, it is not. We have a whole group of people that we work with, including counsel, staff attorneys, and others that we couldn't do this without them, including the review that you were talking about that we do on case law. I'm essentially a trial lawyer who knows a lot about eDiscovery because, unfortunately for me, I've been around a long time. Unfortunately for my clients, I've been around a long time, and I do eDiscovery, but I also first chair major pieces of litigation. And Robert, I'll let him speak for himself. He has a slightly different approach and focus, and that's important because we answer your question with that in our background. So, Robert, kind of explain how you come at this.
Yeah, so I think, Colleen, as you said, well, you're kind of a trial lawyer and litigator who does eDiscovery. I'm kind of the opposite end of the coin, or consider myself the opposite end of the coin, where I'm an eDiscovery attorney first who does litigation, antitrust, white collar matters. But my focus and primary focus of my practice is on eDiscovery. And then, Wayne, to answer your question, I think this is the same for Colleen as well. But at least for me, we get clients from both within the firm and then externally coming to us in the first instance.
Absolutely.
Yeah, and so there's really no one single source where we get kind of our work. We each have really wonderful clients who we have long-standing relationships with and helping with, and then in addition we have a lot of relationships within the firm where we assist our Sidley colleagues on complicated eDiscovery issues.
And that's changed over time too, don't you think, Robert? Because originally, you want to go back 15 years, we wouldn't have been brought as often to pitches for eDiscovery reasons, or been part of the materials on. And now clients, they absolutely want to see that. If anything is going to be a big piece of litigation, they want to make sure that we know how to handle that. And so Robert and I are part of a lot of that now, where at least I wasn't 15 or 20 years ago.
You raise an interesting point that we can jump ahead a little bit, which is to say, how much of your marketing and business development efforts are focused on cross-selling within the firm to make sure that your colleagues know exactly the kind of matters that you are qualified to work with and the kinds of problems that you can help them iron out when it comes to eDiscovery?
I'll let Robert take this one first, and then I can follow up because I'm sure we have a slightly different experience. So I'll let Robert handle that one first.
Yeah, it is important. If anything, just because our group has a fair amount of substantive experience and expertise in these issues. And so we want to be able to offer that experience, expertise to our colleagues and serve as references when they have come with complicated issues. So it does happen a fair amount, and we encourage it. And we encourage it through kind of your normal efforts. Obviously, one, taking advantage of the relationships that we already have. We've both been at the firm a long time, each of us. And so we have historical relationships. But then we put on CLEs and the like. And then we have an internal intranet site that serves as a resource for our attorneys. And then if they have questions after taking advantage of our intranet site, then they come to talk to us as well.
And really, that just to expand a little bit on that, people know who Robert and I are at the firm, and usually within, even say a lateral partner comes in, within weeks they know who we are. It really doesn't take very long if they're in litigation or involved in investigations or involved in regulatory work to find out who we are. But what's really important for us is to make sure that people know why they need to reach out to us, and that does address us training our own people, but that also flows outward. It is both an important internal way that we can keep people, what should you be afraid of? When do you need to come to us? And it's also something that we can leverage outward as we talk to other people. All of those learning, and as we train our people to take on leadership roles, all these things are part and parcel of both internal practice development and external practice development.
Well, that's a great segue. Let's talk a little bit about your own marketing and business development efforts, both as it relates to the practice group, but really, I would like to hear about your philosophies and your mindset about marketing and BD as you came up, because obviously, I shouldn't say obviously, most associates are not thinking about marketing and BD when their heads are down and they're billing 2,000, 2,500 hours a year. But I'm willing to bet that partners don't get to be partners and practice chairs don't get to be practice chairs if they weren't active marketers and business developers. So I'm curious how business development and marketing has played a role in your career and how it's developed as you've been at the firm and have gone through the associate phase and now the partner phase.
Robert was an associate sooner ago than I was, so I'm going to throw that ball to him to handle, and then I'll catch the frisbee on the way back.
Right. Well, for me, thanks, Colleen. For me, Wayne, you're exactly right. As far as that was my experience as an associate, senior associate, even a junior partner, where I kind of had my head down and was just focusing on the individual cases. And it wasn't until several years after I was a partner where I was doing significant and really focusing on eDiscovery, but I wasn't thinking about, the broader kind of environment and practice issues. And so, at least for me, what I did is I tried not to focus on one particular approach. So I try and publish both articles and more substantive law review articles. For me, I have a side interest in machine learning and the law. So I have several technical articles, research articles that I've done there, but also more on like getting involved in lots of conferences, which I know is both really publications and conferences are true for Colleen as well. But just being involved I'm in the steering committee for Sedona conference. I'm heading the advisory council for the EDRM, and along with obviously other conferences, participating in them. But I felt that has been really important for marketing, but also for myself and my own professional growth and learning.
So I agree completely with Robert, and I'm going to turn and something he's forgotten about, I think. Robert and I actually put together an internal business development plan for our group and for our associates and our council. And we got feedback from members in management, and I think at least I have used that, particularly the feedback, as a way to continue to it's not, as I said, it's not just Robert and me, and it's been a way to continue to expand both internally and externally. And this is just going to sound kind of ridiculous, and people say this, but coming in and kind of saving the day on multiple cases. Robert, you've done the same thing where Sidley gets brought in to, quote, save the day because something may not have gone as expected or as planned, and you start to develop a reputation. I had a federal judge say to me, "Miss Kenney, I've heard about your ESI protocols," the first time she met me. That is all practice development when everyone in the courtroom heard her say that. So those types of things, and it's not unintentional. To be clear, Robert's exactly right. It is all, it is, some of it is lucky happenstance, but most of it is not lucky happenstance. It's hard work.
I like the idea here where it's still, I think, an emerging legal practice to be able to position yourself through marketing materials, through content, through articles, through speaking engagements, because I think it's very easy in many areas of the law. It's very easy to come across as having a superficial understanding and superficial mastery of the law, but you can tell pretty quickly when someone is really an authority when the topics they're getting into are complex, they are tricky, they are at the tip of the spear, and certainly any technology-related practice, even like obviously the eDiscovery and data analytics practice, that requires you to stay at the state of the art and at the tip of the spear. So I think that it's interesting how you could use content and what the depths you can dive into with your content. Some people might say, oh, well, that's just too complex. Why is Robert writing a law review article about machine learning? But for the people who need to know that Robert and his colleagues at Sidley are knowledgeable and authorities, that article speaks volumes louder than a superficial blog post that some other law firm put together. So I think it's okay to dive deep and go in depth, because you might turn away some people, but the people who need to be comforted by your knowledge and expertise and wisdom will be comforted by that level of specificity and depth.
Well, we have to stay up on the, literally there's a new case every week, and the area of focus changes gears all the time on every variety of topics. And I think it's fascinating. I really think it's a fascinating area of law. And so, Robert, I know you read cases every week. I'm reading cases every week. I never, ever stop keeping up on the law.
That's a beautiful segue to a bit more discussion about the eDiscovery update that you are doing. To many people, the eDiscovery update might look like a simple monthly compilation of recent cases concerning eDiscovery. For those of us who are in the know, nothing is as simple as putting together a handful of cases and publishing on a law firm's website. So I'm curious if you can walk us through how this idea came about. I went back, the most distant edition I could find was January 2020. I'm curious if it was established before that and what the practices, marketing and BD efforts were before the eDiscovery update. Because again, I think it is a masterful example of using your knowledge and wisdom to provide information that could be desperately needed by the public and potential clients and referral sources. But I'm assuming that it didn't just come with a snap of a finger. So I'm hoping you can walk through the idea for this eDiscovery update and what you were doing before it as part of the marketing and BD for the practice.
Started as an internal resource. Were you involved really early on, Robert? I just don't
I was not.
recall. Okay, so I didn't think so. I didn't want to jump the gun there. It started as an internal resource, and it didn't take but one or two people saying, hey, can I send this to my client? We've got this issue, for us to quickly realize that it should also be used as an external resource. The updates have switched primary ownership over as people have retired, but it has always been an extremely thoughtful piece. It isn't, as you know, because you read it, Wayne, it isn't a flyby, quick 2-line summary. It is really a thoughtful analysis of the issues in the case, not just a holding or a ruling. And we all I say them like they're alive, but we all take they kind of are alive. We all take those updates very seriously. We all read them before they go out. We all read them before they go out internally, and they always go out internally first. And if and occasionally someone does write and say, hey, what about this? I was at that argument. Did you know? And we'll revise. So we take the whole process very seriously. I cannot tell you when they started, but it was long before 2020. Long before 2020. There was at least it could have been the 20-aughts. It was because it may have started right around 2005 when, I'm sure it did, right around the rule changes in 2005. Maybe it was 2006. So it's been around for a very long time, and it has been taken very seriously for a long time. A lot of people rely on information in there. But Robert, like when you were an associate, how did you perceive those? Because I know they would have gone out to you.
Yes, well, it was a constant reference, right? And that's the goal. And I think it's worth noting right now the work involved is undertaken by our partner Tom Paskowitz in the New York office, and with a lot of help from our New York associates helping to draft it. And Wayne, you actually, speaking of marketing, the fact that they're not all available publicly is something we've been working on with our IT folks to make them more searchable. So that is a initiative that we have, but you are right that they're not all available right now. But to Colleen's point, they've been going on for well over a decade now. And so we do have quite a bit of essentially a library of case notes. And so the next goal is to make them searchable and indexable and more available to practitioners.
And we should give a shout out to Matt Jackson on that, Robert. Yeah. He's been doing our counsel, Data Analytics eDiscovery Council here at Sidley. Matt Jackson has been doing yeoman's work on that.
Can you walk us through the workflow? How does the group of cases get assembled? And then what is the process? Who was in charge of that? And how does it make its way to the nice polished prose that we see on the website?
It's from a lot of different sources. So it's, if I see a case, if Colleen sees a case, if any member of our group sees a case, they forward them to typically Tom Paskowitz. Also, we have, your Westlaw, Lexis keyword searches that we run on published cases as they get published. Other secondary authorities, we monitor those to make sure we're being comprehensive. And so we have a lot of inputs, a lot of different feeds coming in, some more structured than others. And then we essentially select the most notable cases out of that, monthly feed. And then our group of associates help prepare summaries, and then Tom helps finalize them. And, obviously then there's some editing help from others that go into it to make it into the final product.
Do your marketing or BD folks play a role here?
A little bit. They certainly help us get it out, but I wouldn't say that they are playing the role like a substantive role.
And it doesn't seem to be much design needed like you would for a newsletter or a glossy white paper, right? It's just straight to the internet.
That's right. It's the goal here is really to make a consistent resource for timely and consistent resource for our clients and for practitioners generally. And so the goal is we don't want to get bogged down in, formatting or kind of the user interface. Instead, we just want to make the content available and make it available as regularly as possible and around the kind of a same cadence as possible, such that people can rely on it as far as a source to look to every month as far as worth reading for their own practice.
If you had to guess, how many hours do you think go into publishing 1 month's worth of updates?
50, 60. Robert's smiling. What do you think, Robert? I'd say 50 or 50 to 75, depending on the month. So many cases get read to narrow them down. It's hard to put in, like all the sources Robert was talking about. We all read cases. I read cases. I forward them on and say, hey, this one's interesting, or I might be involved in a case and it's not even a published opinion yet, and I might forward it on. So I think in terms of the associates, Tom, it's probably 50 hours, 50 to 75 hours a month.
What level does a case have to get to pass muster and be included? Is there certain aspects that you're looking for, whether it's a novel decision, a novel set of facts, maybe a very common set of facts that you haven't seen the law applied to? Where do you draw the line of something being included, a case being included?
Well, those would all be included to the extent we happen to get something that was both new, novel, important. I mean, there's so much going on in this area of the law. I think we try to focus in on that which is most concerning to our clients at any particular time, or that which should be most concern, be of concern to our clients, or things that we are seeing a change. Like the law is starting to change in this direction. This area of the law, like almost every other area of the law, is a pendulum and things go back and forth. And so when we try to catch things on the upswing or the downswing so that we can let people know about it, I don't think we have formal, structured this yes, this no, here's our checklist. Every month is different depending on what's going on.
What's the feedback been over the years? Can you look to certain clients or referral sources or other recipients basically proving the fact that this is worth the time every month to put in and publish publicly, not just to keep it an internal resource?
Yeah, so certainly the feedback from my perspective has been uniformly positive. I think the clients and others appreciate the effort and just the work involved in identifying cases that might have otherwise slipped through the cracks. And so oftentimes when we start working with new clients, we will either add them or they will affirmatively request to be added to the case notes. And it's just a good way to make sure that, both our clients and others are aware of kind of the notable cases that are going on. I don't know, Colleen, if you had other thoughts.
I've had people reach out to me directly and just want to discuss something on there. I sometimes wonder why I'm the one to get those reach outs, but I do get them. I have my own suspicions, but I get them, several 10 times a year, maybe someone will just reach out to me to talk about a particular case note, or to usually a phone call, sometimes email, or to say, can you please add my colleague so-and-so? We just got that, Robert. We just got someone who reached out to us and asked us to add their colleague to our case notes. So sometimes they reach out to all of us. I'm sure Tom gets direct reach out. You probably do too, Robert. But to me, that is telling when people are just blindly, coldly reaching out to me and saying, hey, I read this. I thought it was really good. Could you add me to your list, or do you have time to discuss the holding, or other things like that. So I think in addition to everything Robert said, that's something that is affirmative immediate feedback.
Are these clients? Are these would-be clients? Are these random professionals across the legal industry? I'm curious who the people are who are reaching out to you to chat with you about this stuff.
Yes, yes, and yes.
Okay.
It's a pretty diverse group.
Yes.
Which we get reach outs, and also just kind of it's a good, in the sense that it's substantive. Like my sense is from talking with people that it's welcome, right? Because I think clients get bombarded with a lot of different client alerts and what have you. But for our case notes, it's substantive. We have essentially a summary up front so that you can check to see whether you want to kind of dive into the cases. So really, it's only a minute of your time to scan our summary, essentially executive summary. And I think people appreciate that it's worth opening, it's worth checking, it's worth their time.
Or this month I don't need to. I don't see anything I see this month, but maybe next month I will.
Exactly.
Or they say things like, I've had these reach outs too. I know you wrote something about possession, custody, and control of phones. I can't find it. Can you forward that one to me? I get those kinds of reach outs too. So things, that kind of executive summary Robert's talking about, sticks in their head, and then they use that as a launching pad.
Yep, and I thought that as a well done aspect of the content is that you get enough to know. Basically, you get enough to know whether you should dive into the case or not. It's just a well done executive summary, and you don't have to go searching through 15 paragraphs to find out this particular case wasn't relevant to your concerns, and you spend a few minutes of time wasted going through a case that really wasn't applicable to you or your situation. Can you draw a direct line between this effort and opportunities to pitch clients or bring clients in, to perhaps new referrals or even invitations to speak or write?
Definitely on the latter. So both of us have served many times as speakers on developments in eDiscovery case law. And at least for me, I know many of those reach outs were based off the case note work and publications that we would be sending out. We also included in our kind of standard marketing materials, like RFP responses, that this is something that we do. I think it's helpful for other aspects like chambers rankings and the like. So I think there's a lot of usefulness that just goes out, again, for the substance, the underlying substance of the publication.
But I will say that I've never had someone say, I'm hiring Sidley because you do a really darn good case notes. So if you want a direct pointer, I think Robert's are about as, that is all 100% accurate, everything that Robert said. But, on the other hand, if you want me to draw you a straight line with an affirmative quote from someone, I'm not going to be able to do that. And we should back up a minute and really thank Alan Gillot, our former partner, who came up with the format of those case notes. So that is in large measure his genius. Hello, Alan. We still miss you.
Well, and I realize I ask a tough question because these days with so much content available, just look at what our own buying habits are. Rarely will we see one article and say, okay, this is the accountant we're going to hire, or this is the accounting software we're going to use. Typically, you need to look at 3, 4, 5, 10 pieces of content and then maybe talk to someone who used that provider. So it is rare to get a direct line, but it's nice to know that there is momentum here where the impact of the discovery updates have compounded over time, where your practice is known as a leader in the space for a number of reasons. But one of the reasons that you consistently are displaying your knowledge and your wisdom each and every month in nice short executive summaries and more detailed descriptions of cases based on this discovery update. That's marketing and BD at its finest, where it's not going to always lead to a new client directly, but it allows a relationship to build and allows the recipients to see you all as leaders in the field, which someday could translate to a potential engagement or a referral to someone who is ready to engage you.
We probably, Robert and I, I'm thinking of one particular thing, Robert, that you and I have done together that probably could be tied directly, but that's all confidential. We can't talk about it. Unfortunately.
A cliffhanger that won't be revisited in any future episodes. I'm curious about your philosophies on content, and I'm talking about philosophy like quality versus quantity and speed versus depth, because these are things that lawyers deal with all the time. They wrestle with, this case just came out on Tuesday. I know the firm across the street or upstairs is going to be publishing a client alert today, tomorrow. Do I want to rush and get out something as soon as possible? Or do I want to take a few more days and provide perhaps a bit more of an in-depth analysis than our peers who are just racing to get something out? And then likewise with quality versus quantity, as you mentioned before, you've got a fair amount of cases each month normally that you are wading through to produce your eDiscovery update. How do you balance the quality of your analysis and picking quality cases with that lawyer tendency to be terrified that we leave anything out for fear of it coming back to haunt us 6 years down the road?
So I can go first. So I think for me, we tend to prioritize quality over speed generally. So in the case notes, we are not rushing out client alerts on a particular case. Instead, we have the same cadence of the case notes where they're either at the end of the month or right at the beginning of the following month. And so that cadence doesn't change depending upon when cases are getting published. Also, while we have the case notes, while we have talked about having a blog, we do not have a blog. And so we kind of made a conscious decision to shy away from, trying to do that, 6-hour turnaround, but instead, to the extent we're publishing something, it is much more of a longer turnaround time, whether it's articles or law reviews, whatever it is, or the case notes. It's more of trying to go with a more thoughtful approach to the publications. I don't know, Colleen, if you had.
No, I agree completely. Obviously, there's certain things that we've all published that haven't been as deep and legal insight as other things. And that's a good mix. It's good to have both kind of, I call them practical pointers. So we often publish things that are short to the point, practical pointers. And you can do those a little bit more quickly. Nothing is ever rushed at Sidley. So we don't rush these things. You make mistakes when you rush things. And thoughtful pieces are way more valued than a quick blurb that nobody pays any attention to. It's also it's more useful in every aspect. But we do some, I call them practical pointers. Those are much more quickly done. And they have a different intended audience. They're useful. They're helpful. I like them. I like to end every one of my presentations. Robert does the same thing with, what does this mean for you? Like, why do you care? Sometimes I call that slide, why do you care? And we try to do that as well. And those typically could be done a little bit quicker because we're not basing it on a brand new case that came out, but on years of experience. So I like to think we're a little bit of a mix of all things. And Robert, your law review article obviously takes even longer than the monthly case notes. So I would say that we cover the waterfront. We don't do a lot of quick blurbs out, but we do some things much more quickly than other things, and some things with a tremendous amount of research and insight.
Based on all the time you're spending writing these case updates, writing and culling through the cases that come through every month, are you using the eDiscovery updates as the foundation for additional marketing or business development efforts? Are you doing webinars for clients, either private webinars for clients or more general, open to the public webinars? Are you doing research papers? Are you synthesizing case trends in terms of either predictions or other standalone content? Are you using and repurposing all of this wonderful energy and what I would consider to be like marketing work product for additional marketing and BD content?
So we've been talking about this very thing.
Yes.
Right? So it's definitely, we want to take more advantage of it because I do think it's a resource. We have been talking about kind of year-end reviews and type publications and coming out more with kind of adding a newsletter aspect to the case notes for the reasons that you mentioned, like to leverage the work product, to make it even more valuable to our clients and practitioners.
We haven't done it yet is the answer, but it is something that the short answer to Robert's very nice description was we haven't done as much as we could yet, but we are always talking about it. We have monthly calls with just our team, our senior leadership team. this is something that is always at the top of our agenda. We're also very busy lawyers. We are very busy lawyers. When you say 2,000 hours a year, I think that would be nice. So we're really very busy group of lawyers, which is not an excuse, but it is an explanation. It's why we know as much as we do, too, frankly, because we're living this all the time. But those are very good ideas that we have constantly bounced off of each other. Maybe this year, Robert, maybe next time we talk to Wayne, we'll be able to answer that. Yes.
You could just see some of the potential here where for podcasts like this, you could be sitting down in all of your spare time, sitting down with industry leaders in the eDiscovery space and talking about issues of import to lawyers and corporations and other organizations that are dealing with eDiscovery and data analytics issues. Videos, you could be doing fun kind of explainer videos regarding certain topics that seem to be coming up often in cases and particular factual situations. So yeah, the beautiful thing about all this work you put into the eDiscovery update is that you have this compounding, effective marketing and BD tool that you can use to power even more marketing and BD efforts and separate yourself from your peers even more. Colleen and Robert, you are both very busy lawyers, as Colleen just reminded me. I appreciate you taking the time out of your busy days to chat with me and nerd out about your eDiscovery update and your practices, marketing, and business development efforts. On our way out here, would you mind giving a tip for a practice group, either a lawyer or a marketing or BD person within a practice group who's looking to get something like this off the ground in their respective area? What tip would you give for how to get something like this off the ground efficiently and to be effective when doing so?
Be thoughtful. That's my quick tip would be to be thoughtful and don't rush things.
Yeah. And my other tip on top of that would be don't tie yourself up in a knot about what it should look like, what should the first issue be, because your 10th time publishing is going to be a lot different from your first. There's just a learning process no matter what. So in some ways, it's just better to get started and then evolve as you go rather than, taking so much time on the front end to try and come up with the perfect solution when really the good solution is going to be more for better for the long run.
The old perfection is the enemy of great or excellent even.
Yep.
I'll add something that you often hear in the technology space, which is if you're not embarrassed by the first edition of what you put out, then you waited too long. So absolutely, don't wait. Just get out there, make sure it hits your minimum levels of accuracy and professionalism and polish, but don't make it a whole spectacle because you're going to be losing time and ground to other people who are moving faster than you and who are trying to get into that space and produce their own marketing and BD content that positions them as thought leaders. Colleen, Robert, where can people learn more about you or connect with you if they want to talk to you more about eDiscovery and your practice?
www.sidley.com, and you can look up both Robert and me. We are both readily available, Sidley. And is there I can't even remember from the external web, Robert.
There is an eDiscovery data analytics website within Sidley, and then obviously you could hit us up both on LinkedIn as well, but happy to talk further.
Yep.
And I will drop all of those links into the show notes for this episode. Colleen, Robert, thank you again for taking time out of your busy days to chat with me, and good luck on the practice.
Thank you, Wayne.
Thank you, Wayne.
Well, that's a wrap for this episode of Legally Contented. Thanks so much for tuning in. Check out the episode show notes for more information about our guests and for links to resources that we discussed during the episode. We'd appreciate your feedback and recommendations for future guests. Email us at hello@legallycontented.com, hello@legallycontented.com. We would appreciate if you told your colleagues about this podcast, if you subscribe to the podcast and urge them to subscribe as well. And while you're at it, maybe you could even rate and review the podcast on your favorite podcast player. Until next time, thanks so much for tuning in to Legally Contented.